We never actually had a chemistry read as Rye and Lily. The first time we met, we had a 3-hour meeting, and by the end of that meeting, I just knew she was Lily, but no, there wasn't a formal chemistry read for us. We did, however, hold chemistry reads between Lily and Atlas, just not with Rye and Lily. So in that sense, I'm grateful and honestly hopeful that the chemistry comes across on screen. Of course, during this process, whether I'm playing Ryle or directing, there are moments when words don't come out the way I want, or we're racing against time. There are always challenges. Now let's talk about Blake Lively, because in my opinion, she really jumped the gun and messed this up. Here's why. Blake filed a request for attorney's fees, punitive damages, and travel damages under Section 47.1. She's telling the court that this decision needs to happen now, not at the end of the case, not after everything is resolved, but immediately. Wayfair, on the other hand, argued that FBHA claims don't have jurisdiction in New York. The law doesn't extend outside California's borders, and Blake isn't a California resident. Plus, the alleged conduct didn't even occur in California. Under FEHA guidelines, extraterritorial application is only allowed if there's a strong enough connection to California. For example, if an employee lives and works in California, FEHA applies. But if the employee works entirely outside California, FEHA doesn't apply, even if their employer is based in California. California courts have repeatedly emphasized that FEHA doesn't extend beyond the state unless there's a direct nexus, like the employee working there, the harassment happening there, or the employment being managed from there. Blake is trying to claim California law applies simply because Wayfair, a California company, filed its claims through California attorneys in a New York court. But that's not how FEHA works at all. Here's something else I uncovered. When the judge dismissed the case against Wayfair, his 132-page order never actually established which state's law applied. The motions were conflicting. Reynolds and Sloan argued for New York's anti-slappy protections, while Blake pushed for California Civil Code 47.1. The judge avoided choosing either side, writing that the applicable law couldn't be determined without further factual development. He also made clear that he hadn't ruled on whether Blake's statements were privileged under California law. That means before anyone could even request fees, the court first needed to establish which state law governed. Since no choice of law was made, Blake's motion was premature. To make that determination, the judge would need to weigh whether California or New York law was more appropriate. And here's where the conflict lies. New York law: no treble or punitive damages for defamation beyond common law punitives. Anti-SLAPP Section 70A provides mandatory attorney's fees if a defendant wins. California law, 47.1, allows attorney's fees plus treble and punitive damages for successful harassment complaints. So which state has the stronger interest? The factors mostly point to New York. Blake is a New York resident. The lawsuit was filed in New York federal court. The alleged defamatory statements were published by the New York Times, a New York-based outlet. And reputational harm is presumed to occur where the plaintiff lives and works, which for Blake is New York. Yes, there are California connections. Wayfair is a California company. Blake's California CRD complaint ties into the statements, and Wayfair used California attorneys. But that alone isn't enough to override the presumption against applying California law outside the state. In short, since no choice of law was established, Blake's filing was premature, and the judge can't award fees or damages until that threshold issue is resolved. The court essentially said, "We're dismissing this because, regardless of which state's law applies, New York or California, the outcome is the same." In other words, under both sets of defamation laws and under either litigation or fair report privilege, the claims would have been dismissed anyway. Now, if the judge were to consider remedies or fees, he would need to analyze liability based on two things: where the lawsuit was filed, New York, and where the reputational harm occurred, also New York. That would make New York law the stronger choice. However, if the focus were shifted toward Wayfair's California-based CRD nexus, then California law would have a pull. Still, judges in New York generally lean toward applying New York law unless the California connection is overwhelming. Here's why this matters. If New York law is applied, Reynolds, Sloan, and Vision PR could seek anti-SLAPP attorneys' fees, but Blake could not pursue treble or punitive damages. If California law is applied, Blake could pursue remedies under Section 47.1, but Reynolds and Sloan would lose access to New York's anti-SLAPP protections. The judge cannot apply both. He must pick one. When he dismissed the lawsuit, The judge told Blake that she couldn't come back to court with this type of request unless circumstances changed, such as the choice of law being settled, or new facts being presented. Wayfair pointed this out. Because no choice of law has been established, and because malice has not been adjudicated, Blake's motion is premature. Blake's attorneys argue that malice doesn't require an affirmative claim to be tried in full. Technically true, but if her claims never reach trial, then malice must still be tested either through an evidentiary hearing or another fact-finding process. Right now, there is no record proving her statements were made without malice. Blake is essentially asking the court to assume that, because Sloan and Reynolds weren't found to have acted with malice, the same must apply to her. But that's not what the court said. The court only noted that Sloan and Reynolds had no reason to believe Blake was lying, not that Blake herself knew she was telling the truth. That distinction is critical. This highlights why Blake's motion is premature. The judge hasn't decided which state law applies. He didn't dismiss the claims under California Civil Code 47.1, and the prerequisite finding that Blake acted without malice has not been made. Instead of waiting for the court to decide choice of law, Blake jumped ahead. Her motion assumes California law already applies, but the judge specifically said it had not been decided. Defamation claims were dismissed, yes, but dismissal is not the same as a finding of no malice, which is required under 47.1. Blake still needs an evidentiary record to prove she acted without malice. Wayfair is pushing in the opposite direction, telling the court that discovery will show she acted with ulterior motives, not in good faith. Blake, however, told the court it doesn't need to decide that it's already decided. But no one has actually made that determination. Another wrinkle. Federal judges rarely award treble or punitive damages, especially under brand new state statutes with no precedent. Blake is asking the judge to apply a California law that has never been tested in California courts, let alone federal court. She's also asking him to apply FEHA claims extraterritorially, which California courts themselves generally don't allow. And finally, she's asking him to declare she acted without malice, without any evidentiary hearing. It's basically saying, trust me, I had good intentions. Wayfair counters that this is nothing more than her third attempt at sanctions. They argue she's simply repackaging old motions under a new label, this time as a request for treble damages, mainly to generate press coverage and negative publicity against them. It's unclear what the judge will ultimately decide. What's notable, though, is that in his dismissal order, he even relied on unpublished rulings, cases that weren't officially published by appellate courts and therefore don't carry binding precedent. That makes the decision vulnerable to appeal. For example, he dismissed the civil extortion claim by citing Tron v. Eat Club, Inc., an unpublished case that technically shouldn't carry the same weight. He also leaned on an unpublished ruling in dismissing under the fair report privilege, which says the privilege can extend to advance communications to a media outlet, so long as the filer genuinely intends to submit it in an official proceeding. So, while the dismissal happened, it rests on shaky, non-precedential rulings, making Blake's current push for treble damages look even more premature and risky. So let's really break this down carefully, besties. Because what's happening here is not just a matter of Blake Lively filing some paperwork in court, but actually a case study in how legal strategy can completely backfire when someone skips steps, pushes too hard, and doesn't respect the rules of procedure that judges rely on to keep cases orderly. Now, if you've been following this case, you'll know that Blake has been filing motions left and right, motions for sanctions, motions for fees, motions for punitive and treble damages. She's basically trying to hit Wayfair and the other parties with every possible consequence the law might allow. But the issue here is that the judge hasn't even made some of the foundational decisions like which state law applies. And when you don't have that choice of law established, any motion that assumes a state's law already applies is premature. It's like trying to build the second floor of a house before you've even poured the foundation. Now, one of the things that has made this entire case more complicated is the judge's reliance on unpublished opinions. Let me explain why that matters, because I know for some people this may sound technical or even nitpicky, but in the legal world, it's actually huge. In California, unpublished opinions under the state's rules of court are not supposed to be cited as precedent. They don't carry binding authority the way published cases do. They're essentially decisions that appellate courts didn't believe warranted being written into the body of law that other courts can rely on. But here's the kicker. Federal courts sometimes treat these unpublished opinions as persuasive authority. And that's exactly what this judge did. He openly acknowledged in his order that yes, unpublished opinions lack precedential value under California law, but federal courts are not barred from considering them. They can still lend support to an interpretation of California law. So while a California state judge would not be able to cite these unpublished cases in their decision, a federal judge sitting in New York can look at them, consider them, and treat them as persuasive, even though they aren't binding. And that's what happened. The court leaned on an unpublished opinion, specifically Bond versus Lilly, as persuasive support for how California law should be read when it comes to fair report privilege. Now, the judge didn't stop there. He also relied on White v. Gabriel and another unpublished case, Holmes v. McIntyre, which dealt with allegations of sexual assault. In that case, the issue was whether calling someone a sexual predator or accusing them of criminal activity constituted defamation per se. And as the law generally stands, yes, allegations of criminal conduct are defamatory per se because they inherently damage a person's reputation. You don't need to prove damages separately because the accusation itself is damaging enough. But the judge in our case essentially reasoned that Reynolds calling Baldoni a sexual predator wasn't really a factual statement accusing him of a crime. Instead, it was more like a hyperbolic opinion, not a literal allegation. So what does this show us? It shows us that the judge is willing to stretch the law in order to clear his docket. He has demonstrated multiple times that he doesn't want to keep dealing with this case, and is willing to lean on unpublished, non-precedential authority just to push things along. And yes, Wayfair could absolutely appeal this. They could go up to the Second Circuit and argue that the judge improperly relied on unpublished authority to dismiss claims, which makes his rulings vulnerable. That doesn't guarantee they'd win on appeal, but it definitely creates risk. Now, here's where things get especially messy. Blake is asking the judge to make a giant leap. She wants treble damages, punitive damages, and fees under California's Civil Code 47.1. But as we've already established, the judge hasn't even decided whether California law governs. He has openly avoided making that choice, saying he doesn't need to for dismissal purposes. He dismissed the case against Wayfair without picking between New York and California law because he said it would fail under either. That's why Blake's filing is embarrassing. She's essentially demanding that the judge jump ahead, assume California law applies, and then rule in her favor on damages that might not even be available in federal court, let alone in a case where the underlying law hasn't been established. And let's remember, federal judges are notoriously reluctant to award punitive or treble damages, especially when the statutes providing for them are new, untested, and lack precedent. Section 47.1 hasn't even been fully fleshed out in California courts. There's no clear case law guiding how it should be applied, what the standards are, or what the limits might be. And Blake is asking a federal judge in New York to be the first to make a groundbreaking decision applying this California statute extraterritorially. That's a huge ask. It's like asking a teacher to grade your test before you've even handed in all the answers. On top of that, Blake is telling the court that malice doesn't need to be proven in order for her to recover. But that's simply not true under the statute. Section 47.1 requires a showing that the statements were made without malice. The court has not made that determination. Sloan and Reynolds were found not to have acted with malice in the sense that they believed Blake when she told them her story. But that doesn't mean Blake herself is free from malice. There's a critical difference between someone believed me and I knew I was telling the truth. Blake is trying to conflate those two things, and the judge hasn't bought it. And here's another detail that makes this embarrassing for Blake. She has now filed multiple sanctions motions. One goes back to March or April, and the judge still hasn't ruled on it. In fact, none of her sanctions motions have been decided. That alone should tell her something, that this judge is not inclined to hand out sanctions lightly, and probably won't do it until the very end of the case, if at all. But instead of reading the room, Blake is doubling down and filing more. She's essentially repackaging her arguments again and again, hoping that by framing them slightly differently, she'll get a different outcome. But to the court, it looks repetitive, premature, and bad faith. And you can see why Wayfair is making that argument. They're saying, look, she's filed this before. She's just relabeling it as something new so she can get more press coverage and make us look worse publicly. And honestly, that's not a crazy theory. Every time Blake files one of these motions, the press writes about it, the headlines get bigger, and the narrative becomes that Wayfair is being sanctioned or is facing massive damages, even though none of that has been decided. So it's fair for Wayfair to argue that Blake is using the legal process not just for justice, but as a PR weapon. Now, some people will argue, well, the judge has stretched the law before, so maybe he'll stretch it again for Blake. And yes, he has shown flexibility. He dismissed Jed Wallace, he leaned on unpublished rulings, and he has made it clear he doesn't want this case clogging his docket. But here's the problem. Giving Blake what she's asking for would require him to leap over multiple procedural hurdles. He'd have to decide California law applies, even though he said it's undecided. Find that Blake acted without malice, even though no evidentiary record has established that. Apply a brand new California statute in a federal court outside California. Award treble and punitive damages under that statute, despite federal courts' reluctance to do so. Ignore the fact that there are still pending motions for sanctions he hasn't ruled on. That's a lot to ask. And judges don't like being pushed like this, especially when they've already told a party to wait until certain issues are resolved. Remember, the judge explicitly told Blake that she couldn't come back with these kinds of motions unless something changed, like new facts or a clear choice of law. Nothing has changed. So when she files again anyway, it looks like she's ignoring his orders. Judges don't like that. They don't like being told what to do, and they don't like litigants who jump the gun. And this is why, in my opinion, Blake is embarrassing herself. She's skipping steps, demanding rulings that are not ripe, and forcing the judge into a corner where he would have to make unprecedented decisions. And honestly, I think this is going to backfire. If anything, she's frustrating the judge and making it less likely that he'll rule in her favor later, because he's going to see her as reckless and impatient. Meanwhile, let's not forget the bigger picture. This entire case is already on shaky ground because of the reliance on unpublished opinions. The judge has essentially admitted that he stretched the law to dismiss claims. That creates an opening for appeal. So even if Blake somehow got her treble damages motion granted, Wayfair could appeal on multiple grounds: improper reliance on unpublished authority, premature application of California law, lack of evidentiary findings on malice. The whole thing is a mess, and it's one of those situations where every move she makes now just makes her look weaker on appeal. And then there's the fact that the judge still hasn't ruled on motions dating back months. That tells me he's in no rush. He doesn't want to deal with sanctions, damages, or any of this until the core case is resolved. If he hasn't ruled on motions from March, what makes anyone think he's suddenly going to rule in her favor now? It just doesn't make sense. So let's wrap this up with my opinion. I think this motion was done in bad faith.